So everyone, let's now look at the first topic, and this is what we hope to cover today, a distinguishing and a distinction we create between the supremacy of the Constitution and parliamentary sovereignty or supremacy. All right? So remember, law made easy, need to subscribe. All the videos will be posted there, information made easy for you. Let's get into that. It is of crucial importance, everyone, that you remember the material you covered when looking at the sources of law, Module 1, where you looked at the Constitution as a supreme source of law for Caribbean countries, primarily Commonwealth Caribbean countries. And you were able to look at the role and function to see how powerful it is, because now we are discussing it in more detail, talking about its supremacy. You may remember the Supremacy Clause was one of the things that the Constitution contained to show its power. You may remember that it gave role and functions to all our three branches. You may remember that it primarily and fundamentally protects human rights. So those are some of the things you're expected to remember and understand. And if you're a little bit shady and shaky on that, go back to our video on that for Module 1. All right. So this quote taken from the case that everyone in law school, every law student ends up having to know and understand. Hinds and the Queen, Hinds and R to some. Lord Diplock, judge in this case, in 1976, stated that the people for whom new constitutions were being provided were already living in a system of public law in which the local institutions through which government was carried on, the legislature, the executive, and the courts, reflected the same basic concept. So it's essentially saying that it wasn't a switch from anarchy to civility. The people for whom the Constitution was being provided, they were already existent under a system of establishment and civility. But it's arguable here that the Constitution gave it its written form. So that's what I think Lord Diplock is lending his argument to. Now we're going to have a look at the Hinds and R case in this discussion, and I presume it will come up for you. It will be a very helpful case in helping you understand the power of a constitution that's supreme, and it's a Caribbean case. So it's always very useful to rely on your territorial explanations, and most questions that require you to talk about the constitutions of the Commonwealth Caribbean or the separation of powers or even the rule of law, that case becomes very useful among others. You won't rely on it only, but remember Hinds and R. Everyone, remember Hinds and R. If you do public law and you finish public law, ensure that Hinds and R is on top of the list of the cases that you understand and can apply. Remember the objectives that we showed at the beginning. Now the background says the principles of constitutional law sets out the relationship that exists in our countries between the different organs of state, the executive, the legislature, the judiciary. So it lays out the relationship that they will have with each other, and it also lays out the relationship that they will have with us, the citizens, the citizenry. So that's what constitutional law does on a background basis. If you want to say, so what constitutional law, what does it do? Well, it sets out how the relationship between the legislature, the judiciary, and the executive should be. How do they relate? And it also outlines how they as a state, the three combined, relate to the citizenry, to us. The constitution that we speak of when we talk about constitutional law may be written. Ours particularly is. You can download it. You can find it in your files. You can find it online. You can purchase it too. Law students of old would remember a pink version that we were all required to have. But now in this digital era and the improvement of our, government sites and information availability, you can easily find one in a bookstore or online. So go ahead, grab yours if you don't already. That means we have a written constitution, but some may be unwritten, or It may be contained in a single document or derived from a number of sources. Now, what do we mean? Let's lay it clearly. There are some countries that don't have written constitutions, and we know the UK, the United Kingdom, is our prime example. That would be our prime example for this discussion, okay? So in the Caribbean, the Commonwealth countries have written constitutions, independent constitutions. In Jamaica, we know we had ours given to us, and we'll be looking at the process that led to that constitution even coming into force. Some constitutions are considered unwritten, as we have been taught for so many years of the United Kingdom. You can consider it to be contained in many different sources, and you will understand it more when we start to explain how Parliament can be sovereign, and for that reason an unwritten constitution can exist and functions arguably well enough for that state or that nation. So suffice it to say, some can be unwritten, but ours is written, and we can find it in one single document. But in the United Kingdom, you will not walk into a store and ask for the British Constitution or the UK Constitution and expect to have an answer. Now, our Constitution being written is divided into chapters. It has broken down parts, and there are parts that deal with the powers and the functions of the states. So there's one chapter that talks about the Governor General, particularly his role and function. There's a chapter there for the executive. There's a chapter there for the legislative branch, and there's a chapter there for the judiciary. You remember looking at sources of law, go back to it, you will see that clearly laid out. And in the links below, you'll notice there are two links to references that will help you remember the Constitution in a nutshell, and a document about the architects of the Jamaican Constitution. All right, so we'll look at the structure here, and you can have additional information below. There is a chapter 3, as you all know, that deals exclusively with our fundamental rights and freedoms. It has been commonly called a Bill of Rights globally. Now ours face an amendment. It was changed in 2011. We now call it our Charter of Fundamental Rights and Freedoms. Say it with me, Charter of Fundamental Rights and Freedoms. That's chapter 3 of our Constitution. So that's the structure of the Constitution. It's broken into chapters. The chapters give power and functions to the three arms of the state that are supposed to relate to each other. And remember, they're supposed to relate to us as well. That is why there's a chapter that deals exclusively with our fundamental rights and freedoms, which protects us and keeps us among a system of democratic operation. Because how you treat your people proves, how successful and how thriving you are as a nation. So constitutions are created. We have a written constitution, so it goes without saying that there had to be someone writing something or giving something in a written format. It begins in a process of local drafting. And as I said, there's a document I'll be sharing with you on the architects of the Constitution. Let me quickly, because you may want and hide that. Here it is, given to us by JIS, the Jamaican Information Service. Appreciate it. So the architects of the Constitution, we said it began with a process of local drafting, and you're seeing some of the local drafting. Marcus in the for self-governance. So in the drafting of our Constitution, that legacy was carried in, the philosophies that he held, his vision. They wanted to capture that and make it a reality. And here we see Norman Manley, His Excellency, who many of you will travel the halls of the law school, named from his sake. He was, of course, one of the architects that we know primarily standing at the forefront, along with Excellency Alexander Bustamante. So this document will be available for you. I'll give you the link. You can go and read more, and you will see other architects. But I just wanted to touch on that because we're now looking at the process so it can make sense. So the local drafting takes place, and of course, in the bill making process, this is something that is done. Debates, criticisms, considerations, oppositions, support, and propositions on the drafting of the document. Of course, this is an extremely important piece of writing. So it goes without saying that the nation's best, brightest, most willing, and most able, and the most arguably visionably parallel when it talk about self-governance and getting there, this would be done. So after the process of having it debated locally in our country, after being drafted here too, the discussion and negotiation now takes place in England at the Constitutional Convention. This is what would have happened. We don't expect this happening anymore, especially because our Constitution is not something that's going to just be wiped off a screen. Now, ratification by the local legislature is a process by which that document returns to the local state or the local nation where it was. So when we talk about local drafting, it was here. Debates on the draft was here. So 1 and 2, Jamaica. Point 3 happened in England. And in point 4, ratification is a process by which you incorporate an external agreement or an external convention or an external rule into your local law. And when we remember international law as a source of law, remember, for it to be actually enforceable in your country, that international law had to be incorporated into your local legislature by the process of our foreign ministers ratifying that document. So basically making it effective. And you'll see number 5 closing off by saying, in the end, it also is recognized as a United Kingdom Act of Parliament. So the Independence Constitution Act, if you check it out, very, very surely is what they refer to there, where it was actually now recognized as an existing document. Some of you may be asking that question to yourselves or in your head right now. So we debated it here, we brought it to England, then we ratified it here, and then they made it approved in England. So does that mean then that we created our constitution, or did we just have it approved? Well, that's a good criticism, and that's a good question, because that's a criticism that many constitutional theorists still hold. That the Constitution was imposed upon us, and there's a lack of homegrownness to it or autochthony. So it's funny to know that Trinidad and Tobago and Guyana abandoned their independence constitution. So for our regional students, you will have understood the difference there as we speak now. And for my Jamaicans who remember Martin Carter, this is the dark time I love, you will understand the connection when you go back to the history to see why an independence constitution was abandoned immediately, perhaps because of its imposition and its lack of homegrownness. Now, I've just the draft document, the drafter's document. And we showed you Norman Manley, and we showed you Marcus Garvey and Bustamante, and there are others on the document which you're advised to read. So how independent is our independent constitution? Well, Trinidad and Tobago and Guyana could tell us, and they knew. They lack originality because they apparently are what you'd call generic. They're almost a template. In fact, they are a template, and a template is a framework or an outline. So you could actually follow this guide in the future and create a constitution in a post-apocalyptic society, though we hope it never happens. This draft or this structure could just be replicated and provided to a country if it, per se, for bad argument, had been colonized as a new state. So Norman Manley even suggests that approximately 90% of our constitution is the same as existed as before independence. So if it's talking about originality there, it's saying if there are 10 pages in this thing, chances are 9 of those pages were there even before you were independent. So that self-governance that Garvey dreamed of was 1% actualized because that 9 had existed from 1932. So think about that as we go through our understanding of it, and as you read your constitution. If you don't plan to understand public law. Now, you're not being advised to read the entire thing. We'll provide you with the link, as I said, the Constitution in a nutshell, But there are particular sections that one must observe to understand how exactly powers are separated and how we can talk about independence of the Constitution while talking about the supremacy of the Constitution, right? So we return to this quote that we started with. Hinds and the Queen, or Hinds and R. Lord Diplock reminded us, as Norman Manley pointed to when he spoke of 90% being unoriginal. The people for whom new constitutions were being provided, remember this, they were already living under a system of public law. Jamaica was already living under a system of public law in which our local institutions, through which government was carried on, still had the legislative, the executive, the judiciary in effect. So this Hinds and R case that I urge you to remember and use and understand from this day forward is a case in which it was held that it was actually a violation of that doctrine we mentioned called the Separation of Powers Doctrine. Now, this doctrine is enshrined in the Jamaican Constitution. Let's just pause before we read the rest of the understanding to take this in. The Separation of Powers Doctrine is enshrined in the Constitution. This means you may not find a particular chapter that says, this is the separated power. This power belongs to this person, it is separate from this person, and this person is separate. But we know that there are three distinct and separate arms of governance. The organs of state, the three organs of state, the legislative, the executive, and the judiciary. So we know that these three in the Constitution have their own chapters outlining their role and their function. Also, the head of state has his own chapter. Also, the citizenry has their fundamental rights in a chapter too. That means that there are particular powers that are outlined and there are rights and freedoms and responsibilities that the Jamaican Constitution, primarily since we're speaking about that one right now, in this case, in our Constitution, those powers are separate. That is what the Separation of Powers Doctrine means, that these three organs of state act separately of each other. And while there may be a minor overlap in the legislative and the judicial, not the legislative and the executive, pardon me, it still is maintained by what the Constitution outlines. So it means when it's enshrined, it's found in the principles there, but there isn't a chapter that says separations of power, okay? So in Hinds and R, it was the judiciary, it was the court that ruled. Now that based on what the Constitution says, the court said that it was a violation of the Constitution for the Jamaican Parliament in 1976 to seek to establish a gun court where they would give the resident magistrate jurisdiction to judges when that jurisdiction was reserved for Supreme Court judges based on the Constitution. Let's pause and take all of that in again. This case was a case in which the court, using the Constitution, ruled that Parliament had acted in violation. The court used the Constitution, the rules laid out in the Constitution, the principles laid out in the Constitution, and they used that to interpret the actions of Parliament as a violation. This was an important case, and it still is, because it was the first time that happened in the Caribbean too. It was the first time in which an act of Parliament was actually invalidated by the Constitution. You may remember the Supremacy Clause, which says if any law is inconsistent with the Constitution, it is null and void to the extent of its inconsistency. That's at the beginning of the Constitution. So this is the first time that an actual Caribbean state has their judiciary relying on the Supremacy Clause to invalidate an act of Parliament. Now, the Gun Court Act still exists, but the parts that were inconsistent were invalidated because they were unconstitutional. Now, what was unconstitutional? The section which sought to establish a gun court giving jurisdiction reserved for Supreme Court judges and none other. Now, when you observe this case, and you of course are always advised to read the cases in detail, get a little more information outside of this, you will see that this is something that the Constitution allowed. It was not as if the courts decided to do this from a whim, but it was the first time that it was actually relied on, that the Supremacy Clause actually invalidated an act of Parliament. So this case shows you the separation of powers as we promised. It shows you the supremacy of the Constitution as we promised. It shows you the role and function of the three arms as we promised. And it shows you, when you understand the rule of law, that no man or woman is above the law, and Parliament must pass no arbitrary law. These are rules of law. So of course they guide the way in which our constitutions are written, the way in which the separation of powers doctrine is enshrined, and it explains to us why Hines and R makes sense. So Parliament was told by the judiciary that that action, that attempt to establish that power that was reserved for another based on what the Constitution has laid out, and it is supreme, so that section was invalidated. Hines and R, or Hines and the Queen. Another example of our Constitution being structured and prefabricated, as Norman Manley pointed to and Lord Diplock. Remember, those are arguments that you can use if ever asked to discuss the originality of our Constitution and still be able to talk about the supremacy of it. So while it may lack an originality, and we argue that there was a lot of imposition involved, maybe even 90%, as Norman Manley would have said, Lord Diplock also explained that the people for whom this Constitution was provided, they were living under a system, imagine that, which already held that structure. So it being put in writing was a formality which will be observed and has been observed, but we observe it as supreme because it not only outlines the role and function of government, but it protects the people. Remember chapter 3, the Charter of Fundamental Rights and Freedoms. So here is the structure on which our Constitution is based. We looked at the process of it being drafted. Let's now look at some of the structures, or if this is the skeleton of a Commonwealth Constitution based on the Westminster model, then we'll understand what Norman Manley and Lord Diplock meant when they said it lacked originality, in the sense that there was something there pre-existent and this just fit the mold. Here is the Westminster model on which our Constitution is built and characterized by. Let's observe. So we know we have a head of state. The Governor General is our head of state, and our Constitution has a chapter particularly for his separate powers. Now, the head of state, we know Her Majesty the Queen Elizabeth is represented by the Governor General. That's his actual position, a representative of the Queen. In Trinidad, we remember we spoke earlier that Trinidad and Guyana abandoned the independence constitutions, so your brain must be ticking now and you're going, well, if they abandoned this model, who is their head of state? Well, their head of state is the president, and the president performs the role that Her Majesty would or does in our stead in Jamaica. So that's something to think about for our constitutional lawyers and our draftsmen and women of the future. The president in Trinidad has the same role as Her Majesty. Another typical structure of the Westminster model constitutions, like ours, is a separation of the head of state and the head of government. You'll notice that the head of our government is our prime minister, and the head of state is the governor general. There's a fusion of both offices, as you know, in the United States. They have a president who represents them, and Guyana. What would the United States and Guyana have in common here? The answer would be a colonial history related to the United Kingdom. So they both sought to have some adjustment to how that model had previously been laid out. Another thing you'll find that Westminster constitutions have is a cabinet government. The Prime Minister, when elected, chooses cabinet members from the House of Parliament, and the cabinet members are collectively responsible to Parliament. Together, those cabinet members, those ministers that we hear of, the minister of this, the minister of that, they compose the executive. Now remember we said there was a minor overlap, and that's where you begin to see it. Because the members of parliament we know are the legislative body, but the prime minister chooses some cabinet members from parliament. Remember, they still are answerable to that parliament. So they are the executive branch, and that's something you'll find in the Westminster model, where the prime minister picks a cabinet, a select members to form his group to work for him. And remember, remember you can jump to the slide on parliament. You can get that video on our Law Made Easy page, so just go and find that one if you want to go ahead and look deeper in the composition of parliament. Another element that we focus on that is typical of these constitutions is that the prime minister must come from the lower elected house, the House of Representatives, MPs. So in Jamaica, we have 63 seats in the House, and that ties into the next 2 points. There's a bicameral legislature where you have a upper house and a lower house. So the lower house is considered to be the House of Representatives, and the upper house is the Senate. So the Senate has 21 persons, but those persons are not those persons who are from the lower house, okay? And the prime minister must come from the lower house. And that explains the democratic process, because we are involved in creating that space. We choose the House of Representatives, our members of parliament. Now, the voting system that we spoke of, think of the 63 seats I just said. There is a similar voting system in the Westminster model constitutions. That means we elect our leaders the same way. It's called first past the post. Now, we don't use proportional representation. First past the post means the person with the most first wins. So the person with the most seats, if it's 32 to 31, the person with the 32 seats would be the winner of that. And that would be, of course, identifying who leads our country. Proportional representation, however, is a system in which the majority of the votes or the minority of the votes, however it may go, if you have 20% of the votes, then you have 20% of the seats. So that is not operating here. The first past the post can be found in the United Kingdom, and it can be found in Jamaica too. So that's the similar voting system we're speaking of, right? The Westminster model also identifies and connotes a separation of powers. We said that already, where there is an outline and a separation between the responsibilities. We do know there's an overlap, but there is no overlap with the judiciary and any of the other two. So that's where we have our best example of separated powers. So while there may be a minor overlap between the legislature and the executive, some theorists may argue it's a major overlap. We know that the judiciary remains independent and separate, and that's one of the best examples of the separation of powers. Sometimes you'll be asked to discuss that point, so do remember that the separation of the powers and an independent judiciary are two connected concepts when you talk about our Constitution and the supremacy that it holds. So we talked in the beginning about a written and an unwritten Constitution. We understand that Commonwealth Caribbean constitutions, whether they were changed or not, they are written, can be found in a single source. The UK Constitution can be found in several sources of law, several sources. So even, for example, a convention that they may sign on to, that may be where one of their human rights can be found. Well, we can find out in Chapter 3, there may be a Convention on the Rights of the Child, which there is, 1989, and they also are a signatory to that. So they may have several sources at which they find their constitutional provisions and rules. But for us, it's one single document. Another difference between the Caribbean constitutions and the UK Constitution is that our Constitution underlines supremacy. It is a supreme source of law, and there is no man or no woman that's above the law in our country. So we are all governed by the Constitution, and we are protected by it. So it's the main source of law, and as we said, it's the parent law. Now in the UK, which we're going to observe now, Parliament is supreme. That's quite a different concept, and especially because of how deeply involved your mind will be and has been in constitutional supremacy and the power and the role and function of a constitution, it might strike you to find out that parliamentary sovereignty or parliamentary supremacy exists in the UK, where arguably Parliament is the one that holds that level of supremacy that we see our Constitution having. Now, the fundamental rights and freedoms are entrenched in our Constitution, in our written Constitution, meaning a simple majority in Parliament cannot change them. It is believed that through a process in Parliament, of course, one of the rules of parliamentary sovereignty is that Parliament is not bound by its predecessors, nor can it bind its successors. How so? Well, a quick tip, there were laws that were passed which, if Parliament decides to pass a law, an act, which tries to bind a future Parliament, they can simply pass another act to dissolve themselves, so they wouldn't be considered as successors, but a brand new Parliament. This is just a little nerd world if you'd like to read up on it. So arguably, Parliament is so supreme that it cannot bind its past nor its future. Of course, there's a benefit in flexibility, but you must hope that we have our best minds altering these provisions. All right? Don't get too worked up about it, but look at how the Constitution is supreme in the Caribbean, and then look at how Parliament is supreme in the United Kingdom. We'll talk about the Constitution's power again in another light, though, how difficult or how easy it may be to change it, and then we might start to see a power again talking about how supreme or how strong or how absolute it actually is. So on the screen are points that talk about the process of actually attempting to alter the Constitution. Surprise, surprise, the Constitution contains its own safeguards and locks and protections. So there are processes written in the Constitution laying out how you change the Constitution. So it comes with its manual, almost like a nuclear football. There's a specific procedure that must be applied, not by one man, one woman, or one ideal, but by a collective consciousness or a collective agreement or idea in order for any of these things to be considered. All right, so let's have a look at these. The Constitution remains supreme. It lays out how it can be changed and by whom and in what degree. There are various degrees of protection, and the deeper it is vaulted or the more safeguarded or the more protected it is the more entrenched it is. So there are human rights protections are deeply entrenched, very hard to change and very unlikely to change. We can have additions to it, but to remove that is virtually impossible unless the will of the people is actually to give away their will. Okay. So in order to change the Constitution, there are different majorities in Parliament that are required. So something lightly entrenched might have a minimum requirement. That is that the majority of the members of Parliament, those who are present on the day, as long as they form a quorum for Parliament, then they can actually make this amendment. Now, this arguably is something that may not be a massive adjustment or a throwing the apples off the cart. It's a minimum requirement, just that the majority of Parliament there at the day. Now, there may be a different requirement for another provision because of how it is entrenched. That might be that you need a simple majority of the particular house. It might be a simple majority of the Senate or the House of Representatives. Just one more than the other. 50-49, 51-49, right? So the upper house or the lower house, depending on what's being changed, it may just require a simple outnumbering of the vote. You also have an absolute majority where both houses have to have a particular agreement. It has to be absolute. And that shows that there's more importance in the entrenchment, right? A 2/3 majority may also be a requirement where, of course, at least 66% of the House must move forward for that decision to be in effect. So it shows you that it's not just something that may be a fly-by-night decision, and it will require consideration, and there will be opposition, as you can expect Parliament going. So changing it is not by implication, it has to be changed by a declaration. It has to be intended. So as we continue this idea of it being debated and it being important and it being given value, it has to be really looked at, because the Constitution is not something that is just picked up, as I said, and rubbed and removed. There's a period of delay in which, of course, information, discussion, debates, observation will go on. Some provisions are very, very important, and they require the citizenry to be a part of it. A referendum. A referendum is when the public is involved in the decision-making process, something that is very important to the future of the country. The members of the country must be involved. Now, there's a difficulty arguably with referendums because of partisan politics, where persons may not necessarily see a bad thing with going to the CCJ, but if their political leader of their party doesn't like it, then they're not going to sign that referendum for us to join the CCJ, for example. So a referendum required locally, though it is understood in our law. Let me say this for disclaimer, though based on all the observations we've done on the research, you're only requiring a majority in the House. If it were that they chose a referendum, it would be because maybe they thought it would be selfish of them to make a decision for the entire will of Jamaica without asking Jamaicans. And the second hand, it might also be a ploy for them to appease their people or either have the opposition strike it down. Because remember, that's the difficulty we're talking about. Partisan politics might become involved. And you don't see anything wrong with having a Caribbean Court of Justice. But because you are of this persuasion and your party doesn't like it, you may not. Another difficulty in changing our constitution, which is a protection, is that there are interlocutory situations where you can't just change one part because another section relies directly on it. So changing that affects the change of another section. So if you want to change this section, it may be delayed because then 4 or 5 other sections may be required to be changed. Perhaps if someone had lobbied to change the constitution so that the head of state no longer be. Of course, it would affect almost all the other provisions in which the head of state is involved. The process of appointing our leader, many of those things. Well, it has been done. Look at the independence constitutions that were done away with in Guyana, the United States, Trinidad and Tobago. So understanding the Constitution and understanding the rules behind it allows us to understand the changing process. It won't be an easy thing, and it must be based on the will of a majority, as you've seen, whether minimum, maximum, absolute, 2/3, or even involving us in a referendum. Right? Now, there are provisions that are entrenched, and we kept saying entrenched, talked about deep protection. Let's see a couple of those deeply protected sections in our Jamaican Constitution. Section 2. Section 2 establishes the following. Subject to the other sections, meaning based on what is in section 49 and 50, we have to take those into consideration too. But section 2 says, where any other law is inconsistent with the Constitution, the Constitution shall prevail, and the other law shall, to the extent of its inconsistency, be void. This is on which we underscored Hines and R. Remember Hines and R now, that the Gun Court Act passed by Parliament, that Act of Parliament was invalidated because it was inconsistent, but not all of it. So to the extent of its inconsistency, it was cut off. Section 34. This section establishes Parliament, and it states that it shall consist of Her Majesty, a Senate, and a House of Representatives. You can find this in the Constitution based on the section. 35 and 36 deals with the Senate and the House of Representatives. 35 for the Senate, 36 for the House of Reps. Section 39 outlines the qualification for membership for the Senate and for the House of Representatives, and Section 63, subsection 2, talks about sessions of Parliament that have to be held within a particular period of time, and it shall not intervene between the last sitting in one session and the first sitting thereof. So it actually outlines when and the periods in between when sessions of Parliament can and should not be held. Continuing, Section 64 talks about the time between legislative sessions and Parliament actually being dissolved or the dissolution process. So it even talks about the termination or the closing of some such and the time between when discussions and sessions can take place while closing of the shop is happening. Section 68 establishes that the executive authority of Jamaica is vested in Her Majesty. That section, of course, is one of those sections that shows what Norman Manley and Lord Diplock would have been identifying, that that structure existed and just now is remained in writing. Just a little reminder, you can do it, you've got this, let's go. We started with a quote from Lord Diplock. Lord Diplock is an esteemed judge, of course. Here we are talking about Dicey's quote now, and he is a constitutional theorist and a jurist, and of course a very profound philosopher of thought in the legal field and otherwise. So we will see Mr. Dicey's name talking about the rule of law when we get deeper into administrative principles of law. I will be using some of his concepts now because in his original writings of constitutional law, he speaks about many things, among others, this is involved. The principle of parliamentary sovereignty means that Parliament has the right to make or unmake any law whatsoever, and that no person or body is recognized by the law as having a right to override or set aside the legislation of Parliament. Now that's in a summation, the sovereignty of Parliament. Don't be surprised. The Constitution was given that power just a few minutes ago. It's now switched to the hands of a human, perhaps a body, an existent living body, and not just a written, entrenched, safeguarded document. Something to think about. Which one would you prefer? An entrenched, vaulted, guarded document, or a fluid, moving, autonomous body of humans selected by their people? Well, our Constitution still allows us to select our body, but they don't operate autonomously. Something else to think about. So, Dicey explains to us that Parliament has control over its internal proceedings. That means the courts will not review this internal process to see if Parliament conforms to the manner and the form requirements for making laws. That can be if Parliament requires it. So they will not review it because they are not mandated to. In our country, we understand judicial review where the courts will review an act of Parliament because they have that power to do so. Parliamentary sovereignty doesn't operate quite that way. Here we are. Now, taken from the textbook on constitutional and administrative law by Thompson, the supremacy of Parliament is a legal doctrine. So we call it parliamentary sovereignty and parliamentary supremacy. So while we have a supreme constitution and our Parliament is limited by the Constitution, you'll see here now that Parliament is not limited in the UK as our Parliament is limited by the written Constitution. They don't have a written Constitution. So the limits that exist on what Parliament can and cannot do is quite different, if existent at all, because we call it parliamentary supremacy, which means it has that supremacy we give equivalent to our Constitution. I just want you to understand that, because in our Caribbean space, Parliament is supreme within the limits that the Constitution gives Parliament. That's what it is. But that limit that the Constitution gives our parliamentarians, the UK doesn't experience that. They don't have that because Parliament here is sovereign. The nature of this relationship is that the courts must give effect to the acts of Parliament. Okay? So it's a legal doctrine which talks about the relationship between the courts and the acts of Parliament. That's what it means. So the acts of Parliament that the courts get, they must give effect to them. The courts may not deny them legal effect as we can do in the Caribbean, as we did in Hines and R. So while we could deny legal effect to the parts of the Gun Court Act that weren't constitutional in 1976, parliamentary sovereignty says that can't happen in the UK. The courts cannot deny legal effect to the acts of Parliament passed. Where we can have that struck out and we can remove the legislation because it's incompatible, the courts under parliamentary sovereignty cannot deny those acts of Parliament legal effect. Right. Here is a case, Edinburgh and Dalkey Railway in 1842, indicating that supremacy of the Parliament that we speak of. Now, Lord Campbell, paraphrasing here, explained to the court, if it appears that a bill has passed both houses, upper and lower, and has received the royal assent from Her Majesty, no court could inquire into the mode in which it was introduced into Parliament. No court could inquire into the action taken before it was introduced, and no court could inquire into what happened in Parliament during the processes of the bill-making process. So that's the exact opposite of what you are introduced to in your Caribbean Commonwealth scene, where Parliament must follow the Constitution when creating their acts, and they must ensure that it conforms to the Constitution, or else. There is no power for the court here to inquire into how it was done, when it was done, or what was taken there, or what happened in the stages of the bill-making process. That's from 1842. Let's look at a second aspect that's explained by Dicey. So we just looked at the first aspect of parliamentary sovereignty, and we talked about it being a relationship between the courts and the acts of Parliament. Okay? Second aspect. Parliamentary sovereignty also means that the courts will not review the acts of Parliament. Remember, we said they must give legal effect to them, right? They will not review them, they will only interpret them. What they can do, however, is a declaration of incompatibility, for instance, with international law. Remember, I spoke earlier that if the UK ratified a convention on how to treat children, if they passed an act of Parliament in their country, which arguably ill-treated children in some way, let's say the Convention on the Rights of a Child says no child should work, child labor is illegal, but there was an act of Parliament which passed, which allowed children to do particular work while not being connected to a work study or not being in a film and doing tutelage, then maybe the courts would declare it incompatible with the international law agreements made by the Parliament. So they're not actually telling them they can't do it. They're just declaring that it's incompatible with previous agreements made. When they make this declaration, although Parliament is not bound by it, as we said, in the Caribbean, the courts would bind and limit Parliament. But when the courts make this declaration in the UK, although Parliament is not bound by it, in practice, Parliament will take steps to make it compatible with whatever areas the policy may have a problem. So what would they do? If the courts declare that it was incompatible with the international conventions that they signed on to, the agreements they made, then they would consider that and adjust their policies through their local legislation to fall in line. But they are not bound to do so. So Hines and R, the courts could strike out the inconsistent sections of the Gun Court Act, because that was in Jamaica, where we have constitutional supremacy. But as we learned, in the UK, where they have parliamentary supremacy in Edinburgh and Dalkey Railway, the courts cannot inquire into that process. They can only give legal effect to it or declare an incompatibility, which Parliament can consider and change, but are not bound by. In essence, parliamentary sovereignty in the UK renders the courts powerless to question the legality and powerless to question the constitutionality of primary legislation that Parliament passes as an act. Now, the third principle is that Parliament is not bound by its predecessors. So what Parliament does today will not bind it in the future either, and what was done by the Parliament before does not have to bind them. So I bring you back to my question. Would you rather an entrenched, vaulted, unoriginal document, arguably, which protects an entrenched rights and provisions, among other things, that are very hard to change, or would you want a supreme body, living, fluid, moving, not bound by its past and not able to bind the future, but supposedly representing the will of the people they serve and the parties that they align with? Bearing in mind, however, that you will still have a body with the book that is vaulted, but they will not be supreme. They will be limited. So Parliament is not bound by the previous Parliament, and what they do now will not bind them in the future. So they can remove acts of Parliament that have been passed previously and put others in force. And as I showed you, there are ways in which Parliament can actually have a dissolution and argue that they are not successors, so they don't have to be bound at all. All right. When Britain decided to grant the countries of the Caribbean independence, it was also stipulated that the constitutions be written. It was required, as opposed to the unwritten system which the UK has. Remember, we looked at local drafting. Remember to look at the document regarding the drafters of the Jamaican Constitution. So the fact that we have written constitutions and we call them supreme, it puts a limit on Parliament. So while we said that Parliament in Jamaica is responsible for doing A, B, C, D, and E, we know the Constitution outlines what they can do. The Constitution does not allow them to do F, G, and H, so they cannot. Hines and R is your prime reminder of that for now. As you go deeper in public law, you will gather more cases and we'll be there with you. But right now, you can use it to understand that with a written constitution that is supreme, the Parliament is given its limit. So if you want to even call Parliament supreme in the Caribbean, remember it is supreme within the limits that the Constitution set for it, because it cannot act outside of that given parameter. Okay? The Constitution also gives the court a duty that doesn't exist in a sovereign parliament in the UK. So the Constitution gives our courts a duty to review acts of Parliament to see if these laws are consistent with the Constitution. Hines and R. The courts had a duty to look into the Act of Parliament to see if they needed to declare it unconstitutional and have it struck out. A system that has parliamentary sovereignty, that would not be a guarantee. It may be a suggestion by the courts, but it would only be mildly persuasive and not binding, because Parliament is supreme. Now, when a constitution is supreme, we spoke of this and I want to reinforce it, that Parliament has their power, but their power is within the limit that the Constitution gives them. That's a major difference with the parliamentary sovereignty. Remember, the definition of parliamentary sovereignty was the relationship between the courts and the acts of Parliament. That's what parliamentary supremacy is, the relationship between the courts and the acts of Parliament. But constitutional supremacy is the relationship between court and Parliament, because the court actually conforms Parliament based on the Constitution. The court lays out that limit, and they're the ones who have a duty to review if they go in or out of that limit. So their lawmaking power is subject to the Constitution, and the courts are the protectors of the Constitution. So you see what's going on. Constitutional supremacy is the relationship between the courts being the protector of the Constitution and Parliament, which is bound by the Constitution. But parliamentary sovereignty is the relationship between the courts and the acts of Parliament, the laws they pass. Remember, the courts don't necessarily have the ability to deny them effect, nor criticize the mode, process, or making. They can only declare incompatibility, which is not binding, and they actually are asked to interpret them because they're already there. So if you remember interpretation of legislation as one of the sources of law in our previous videos, go back to sources of law, you will get a deeper understanding of how it might work in a state with a sovereign parliament. So simply put, in the Caribbean, our Constitution provides the limit for our Parliament. And in the UK, where the Parliament is supreme, they are not given such a limit by the courts, nor can they be. All right, we literally are speaking in step, so let's just look quickly at what our Constitution actually says in this restriction of Parliament. So you're wondering, where in the Constitution can I find this? Go to the section that speaks particularly to the legislative body, the Parliament. It will say Parliament is given the power to pass laws for peace, order, and good governance. So that's the limit that they have. Their laws should be orderly, should be limited, and it should be peaceful and well governed. Throw back to Hines and R, where the Gun Court Act, of course, there was a part of it that proposed good governance and order, but there were sections that were not compatible with the Constitution because of the powers that it sought to give, that Parliament did not have those powers to give. That's what it's saying, right? So it follows then that the law of the Constitution is higher than any law that Parliament can make. Doesn't that make sense? That if Parliament tries to make a law in the Caribbean that is beyond its powers, or it seeks to take anyone else's powers, or it seeks to assume anyone else's powers, the Constitution stands in its way to protect order, because it gives it the power to pass laws for order. And who interprets the Constitution? Who protects the Constitution? The court. That's the independent judiciary that we speak of. So when you remember that the constitutions of the Caribbean have that separation of powers in it, remember that's an example of the separation of powers. That Parliament's power is separate, limited, and of course the Constitution provides that limit, and the court will make sure that Parliament doesn't step out of that, as Hines and R showed us. Right. Parliament may therefore be sovereign in the Caribbean, but sovereign within the limits that the Constitution has set. We keep saying it. So Parliament has power that no other arm will have. There is power that they hold, but that power has a limit set by the Constitution. Remember, in the UK, that limit does not exist on their Parliament at all. They are not bound by their predecessors, meaning their past parliaments, and they cannot bind their successors either, the future parliaments. That's parliamentary supremacy. But a supreme constitution binds Parliament's actions if they are incompatible with our supreme source of law. Wooding CJ in Collymore and AG actually says this, another West Indian case. Parliament may be sovereign, but within the limits that are actually set. And if they act outside of that scope or ambit, they act ultra virus. Ultra virus. Ultra virus. If you're intravirus, you act within the scope of your given power. Ultra virus is outside the scope. Think of yourself as being in the shower. If you're in the shower, you're in the right place. You're intravirus. If you're standing out of the shower, you can't take a bath standing out there. So being intravirus is the place that the Constitution expects our leaders and our functionaries to be. And if they are ultravirus, we now understand how a supreme constitution would handle that. Entrenchment. We remember that in changing our Caribbean constitutions, we must observe particular processes and steps. Depending on how deeply protected some provisions, meaning some parts of the Constitution may be, we call them entrenched. Think of a trench as a deeply dug hole or a ditch, except you put a book inside a vault, and you bury it. So in order for you to even open that document to make changes, it can't be the hands of one man. It takes the entire village. And in this case, our village might be the entire nation. The scheme of entrenchment protects the Constitution from ordinary changes by Parliament. Entrenchment means that the passing of legislation to change the Constitution must follow particular requirements. Like I said, have to go in a particular direction to have any of these adjustments enforced. Let's look at some cases. In Payne and the Attorney General in 1982, it was stated, quote, certain alterations in the Constitution were certainly not left to chance or to an ordinary legislative enactment. Let's think why. If the will of Parliament, for some reason, had been malicious, ill, and sly, and they planned to remove some of our rights because they saw that as a way of moving their way forward, arguably, just theoretically speaking, the Constitution having entrenched provisions protecting those rights, we would have to have a say, not only by legislating and voting on these persons, but we also have our rights being protected as such that they may not be able to touch them simply. And that's what they're saying here, that some entrenchment devices include special formula, they delay, there has to be a special informative session, there must be special parliamentary majorities and Senate votes on it, even referendum requirements, which involves us, the people, having a say in the direction. Now, this ends our discussion for today. When we return, let's have a look at where we pick up, all right? When we return, we will begin to look at the appointment and functions of the head of state. We'll look at the role and functions of the Governor General. Today, we have distinguished between the supremacy of the constitutions of the Caribbean and parliamentary sovereignty in countries like the UK. Of course, we remembered and we observed the characteristics of the Constitution, and you are advised to visit the following documents that will be provided for you: the architects of the Constitution and the Constitution in a nutshell, both provided by Jamaica Information Services. This was Law Made Easy, all right, and we'll see you in the next video.